Good morning. You're listening to Senior Moments on Santa Clarita's hometown station, AM 1220 KHTS. I'm Joel Green. We are talking about issues in aging, handling your legal affairs with Gina McDonald, attorney at law, specializing in estate planning and elder law. So, Gina, the $600,000 to $5 million plus.
Right.
That's the exemption.
Yeah. Well, see, what Congress can giveth, Congress can taketh away.
Okay.
And so we've gone from 600,000, we went to $1 million, then we went up to 3 million, then we came down to 1 million, and then Congress said, you know what, we're trying to figure out what wealthy means. And in their mind, what they did is they said, okay, if we're going to tax what you have in your estate, not income tax, but estate tax, then our definition of wealthy at this point is going to be if you have more than, like I said, 5.4 million, it's indexed going up because it's even more this year, then we're going to decide that you're wealthy. And what we're going to do is we're going to take a portion of anything above that amount and get an extra tax on it. That's a death tax. As I explained to my clients, that's federal. Now, in the state of California, I have come to the conclusion that we don't have a death tax because we kill you already with our sales tax. So, and what's in California, unless you get to that over $5 million mark, there's no death tax payable to California. But in Ohio, Ohio has a state death tax in addition to the federal tax that has to be paid. And so, in one respect, in California, you just have to understand it's the feds that we're going to give you a death tax if you get over that amount. But remember, we're still allowing people to double it. I'm addressing the individual who is between 100,000 and 5.4 million when I'm talking about the type of estate planning that people are doing.
And you mentioned before that the state of California looks at, say you have a home that's worth $100,000, which
there is no such thing as a
California.
home that's worth $100,000.
In California, no, I get it. But let's say that the mortgage on that home is $80,000. Mm-hmm. So really, your home has $20,000 worth of equity.
Equity, yes. But when we look at a probate action, when somebody dies and we have to transfer title of real property to somebody else, the court doesn't look at the mortgage to value the estate. The court looks at the value of the asset, and that's what they base the fees on. As I said before, I just had to chuckle. I don't think there's anything that you can buy for $100,000, especially not out in this area. Normally, I would say you're going to see homes that are between $350,000 all the way up to the $5 million.
And the state would value that home at whatever its current value is.
In a probate action, absolutely.
And not take into consideration any encumbrances on that home.
Correct.
Wow. So,
and that's for determination of the probate fees. It does not mean that within the probate, your representative does not have to pay off that mortgage when they sell the house. And even if they want to transfer the house, there's a mortgage there that you committed to the bank to pay.
And somebody's going to pay it.
You have passed away. Someone has to get a new mortgage.
Oh, of course, that would be a given. So this family is in your office. They filled out this questionnaire.
Okay.
Okay. So where do we go from here? Had they had a chance to review your suggestions to them?
Absolutely not, because I'm just looking at the questionnaire now.
Okay.
And what they're doing is we're going through some of those questionnaires, and some of them are dealing with powers of attorney.
What's that?
For business management and healthcare. The best way to explain it is, normally when we're talking about people's assets, they have some assets that are in their name as individual that are what we call after-tax assets.
What does that mean?
That means that it's not an IRA, it's not a 401k, because remember, while you were working, you put money into those assets, and you did it by being able to get it. You didn't have to pay income tax on that money. It got deducted off of your taxable income, didn't it?
Yes.
All right. So then when you start taking the asset, then it's added to your income for income tax purposes, isn't it?
It would be.
Well, if you have an estate plan and you have a trust, you can't make the trust the owner of that asset, or else all the tax comes due.
Who's the owner?
You are.
Oh, okay.
And normally you'll have a beneficiary designation for it at death. But what happens if you're driving around and you hit the bumper of a Mack truck? You are in the hospital and you're in a coma. Who's going to be able to communicate with the entities holding those tax-deferred assets to get funds out for your care?
Do I designate somebody?
Well, see, the default is if you do nothing, if you have no powers of attorney, then the court system has said, we have a way to manage this. It's called a conservatorship. It's an adult guardianship. But it means someone has to petition a court to become your conservator. We have a probate investigator that's going to have to investigate whether you're the correct person to be doing this, because the court is the parent patriae over, the big daddy over you, and making sure that somebody isn't going to be given the power to handle your assets and then walk off with them. Some people don't like the cost of what it is for a court system to go into a court system and the length of time it takes before you can get to any of the assets.
And what,
so that's why they've signed powers of attorney.
And what, when you say length of time, couple of weeks?
In your dreams. We have, first of all, everything dealing with probate now is not in our branch courts. It's in downtown Los Angeles. We had to do budget cuts, so everything went down to downtown Los Angeles. In addition to that, we have a lot of courtrooms there, but you're going to be first having to prepare the petition, then file the petition with a approximately $425 filing fee. You will get a hearing, hopefully in a month. Then you will have to attend the hearing, and there are probate referees that have to finish their reports before that time. If they don't, the matter gets continued until we have a hearing where a judge approves the conservatorship. We have no conservator appointed.
And how long is this going to take? Roughly?
Again, I hate to say this, but it depends. How much information does everybody have put together on the paperwork that's submitted? What is the probate investigator questioning or adding? Plus, the person who's asking to become your conservator has their attorney.
Of course.
And then the person who is going to be conserved, which is you, remember, because you
Right,
hit the
right.
bumper of a Mack truck,
Right.
okay, has to have their own attorney because we have a constitution. And we want to make sure that you have the opportunity to be heard, or we have someone who's looking out for your interests. That's another lawyer. Do you see how much money your estate is paying? And people are making loans to you to pay your medical expenses and everything else until we have somebody who is appointed as the conservator.
Wow. That's an awful lot of hoops to jump through.
So then I have to ask you, Joel, who do you trust? Because
Gina.
when you're doing a power of attorney for business management, what you're doing is you're naming someone as your agent. We normally do it so that you're naming an agent. If this person can't serve, you're naming another person. If they can't serve, you're naming another one. Because unfortunately, as I tell clients, this is a volunteer position. They don't have to accept it.
Oh, no, they have to. Okay, we're going to be back. We're going to take a break. Do you have a legal plan in place? Well, if you don't, you need to. Gina McDonald will tell us what we need to do. You're listening to Senior Moments on Santa Clarita's hometown station, AM 1220 KHTS. Good morning, everybody. I'm Joel Green. We are listening to Senior Moments. Do you have a legal plan in place? Why don't you? For you and your family. Our guest today is Gina McDonald. Gina, what makes for an estate plan?
Normally, what we're looking at is, and I always tell people, take a look, because you're normally going to have either a manila envelope with a lot of documents in it, or you're going to have a binder with copies of documents in it. It's going to have, if you have a trust, it's going to have a trust. It's going to have something we call a will. We, in the industry, a lot of times will call it a pour over will, because we always have the client do a will, because that will is saying anything that is outside the trust at my death, I give to the trustee of my trust to be distributed per my trust document. And people will say to me, well, why do I have to have that, Gina? And I always give them the lottery ticket example. I tell them that the day before you die, you went and you bought a lottery ticket. And you turned it over and you wrote your name and address on there like you're supposed to. Well, guess what? The next day you find out that you won the lottery. You're so excited, you have a heart attack and you die. All right, how are we going to get that money into your trust? Because that will be payable to you as an individual. So that will be payable to your estate. Well, that pour-over will says anything that I have that's outside the trust, I give to the trustee to be distributed. If it's over $150,000, because we have a code section in the probate code to avoid a full-blown probate and use an affidavit if it's 150 or under. And so if it's more than that, we're going to have to open up a probate, but at least we have a will that says give it to my trust so that it will be distributed per my trust document. So now we've talked about we have usually a revocable trust.
What does that mean?
A revocable trust means if you change your mind, you can make an amendment to the contract. An irrevocable trust says that's it. What I wrote for most layman purposes. A revocable trust, I normally tell clients, becomes irrevocable at your death. Because unless you've learned how to get your hand out of the grave to sign an amendment, it's set in stone, isn't it? So we have the trust, we have the will. Now, a lot of that is, the trust is for during life and death. The will is at death.
Do people need to have both in place? Can
Yes.
you have one but not the other?
Sure, you don't need to have a trust. When people do a trust, it's really not for their benefit. It's for the benefit of the individuals who are left behind. Because what you're doing is all of the footwork that the executor would have to do if we're probating the estate. You're having to change ownership of assets into the name of the trust. You're having to do beneficiary designations, and that's all during life. And so it's not benefiting you because on a revocable trust, the identification number for a revocable trust for tax purposes and everything else is your Social Security number. That doesn't change until you die. And if you're a single person and you have the trust and you die, then we're going to have to get an employer ID number for that trust after you die, because it's turned into a little mini business that you're saying to the trustee, when I die, gather my assets, pay my bills of last illness, pay my funeral expenses, and then distribute out as I have set forth in this document or any amendments I have made during my life. But you're doing that as to help the individuals who are going to receive assets avoid the probate at death. Other than the trust and the will, then during life we're talking about powers of attorney for healthcare, powers of attorney for business management, HIPAA authorizations. We're normally creating deeds, transferring the assets, trust transfer deeds, transferring the real property into the trust. That's how we, again, avoid the probate.
And we're doing that while your client
Yes.
is still alive.
Correct.
So that when everything is in place,
Yes.
it's a smooth transition.
And even when things aren't in place, for a lot of people, my cautionary tale to most people is, if you tell me that you have a trust, I ask you to bring it in, and then I ask you to bring in all documentation regarding your assets so we can figure out what your trust really owns and what you own as an individual. Because that's how we can figure out whether we have fully, in quotes, funded the trust.
When we come back, we're going to talk further with Gina McDonald about handling your trusts, other legal documents that you need to have in place. Trust today, elder law today, and planning today is our issues on aging, handling your legal affairs on Senior Moments. We'll be back right after the break.